What's up, YouTube? Ion UTV back in the building. Today we finna demonstrate about the YSL trial. The defense has filed the motion to recuse the judge, meaning they don't want him on the bench or overseeing the case anymore. And the some more lawyers then filed that also. So we're gonna take a look at that and we'll react to a couple of more things after that. Let's go.
We filed as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
Please. And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
sure,
it can certainly be. I mean, the appellate court will review my ruling for abuse of discretion.
Certainly
okay.
Understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. Well, I'm not going to get into any argument, but I can't. Okay. So that's your assertion at this point in time, and like I said, when that is taken up, I'll consider it. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time,
sure,
other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady, and for that, and I will do that. And then so if that pertains, or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay. All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also...
But I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I'm confused. How do you make a mistake in the courtroom from what one part of either the state or the defense? It's the defense saying that you made a mistake, and it's some more lawyers backing him up saying that you made a mistake and they would like for you to be recused from the rest of this trial. It would seem like to me that another judge or some other proceedings probably would have to be, just what I'm thinking, I'm not a lawyer, nothing like that, but would have to be held, and for I think another judge to choose whether he should be recused instead of, how do you get a chance to be a judge and then have a strike against you, have lawyers pulling it out, and you make a ruling on it? You ruling on your own mistakes. Just want to go on, man. Let's let him finish.
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, as best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parrish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal 392 Division 1 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a...
See, he had got that information from another lawyer. It was actually, I believe, YSL Woody's lawyer. After she wanted to be done with the case, he fired her in open court. But on the way out, she gave Brian Steele the information because she was there. Let's go.
As a witness in the trial, I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it. And
now he is coming right back with, check out what he's finna say.
That doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not gonna, Mr. Steele, I can't argue with you about anything such as, I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Ms. Weaver is gonna prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right. Okay. All right. Let's turn now to the statements or interviews from January.
Not to interrupt the court.
So, they filed a motion to recuse him, get him off the bench. He came right back at them with a nah, not right now. Again, I don't understand. Well, maybe I'm not. I have not studied the law, so that's probably why I don't understand. But it's really funny for me to have a judge be called out on one of his mistakes and he make a ruling on it. You would think that they probably would have another judge step in on it, a separate hearing with somebody else, seeing if he's in the wrong or not. But I guess, the law varies from state to state, and that's how they get out in Georgia. But right now, man, in this case, how do you feel about this case, man? How do you feel, man, in the comments, bro? Every single witness just about have, and most of these are the state witnesses. 90% of them are the state witnesses. So most of them has not really had anything really forthcoming to say about if he's guilty or not. Most of them didn't want to be there. I don't know, man, but I'll be back with some more on it the next court date, bro. Like, share, and subscribe to IOU TV. We working.